I'm David DeLugas, the $99 lawyer. This week's question is, should I send a confirming letter or email whenever there is some agreement reached? The answer is yes, do it. Now, whether this is for you in a business sense, business context, or in your personal life, whether it's with a vendor at the repair shop, an auto mechanic, a friend, a relative, your ex-spouse with whom you have reached some agreement or an accommodation, send a confirming email or letter. Now, in this day and age, of course, it's easier to just send an email. So what should it say? Well, please do not write something like this. This is to confirm that you and I reached an agreement this day at such and such a time, and that you are going to do A, B, C, and D, and I am going to do 1, 2, 3, and 4. Now, that would work if you're trying to confirm the agreement that you reached, but wouldn't it be a lot more pleasant for you to write and for the other person to receive, and less likely to cause problems if you were to say, "Dear so-and-so," or "Tom, this is to thank you so much for your time today on the phone, and I'm glad that we were able to reach an agreement, accommodation, whatever the term that's appropriate for your situation. We're glad that we were able to reach an agreement, and that I'm going to do this and you're going to do that, and how wonderful it is, and I really look forward to this working out to our mutual benefit." Or if it has to do with your children, dear Sam or dear Kathy, glad that we were able to work out our kids' schedule for next week, and so I'm going to pick them up after their school day on Tuesday and make sure I get them to the store and take care of their soccer equipment, and I'll send you the receipts for that stuff just as like we talked. Hey, really glad we were able to work this out. Terrific. Let me know if there's anything else I can do that'll help us along, or something like that. Now, what have you accomplished? Why do that? First of all, you will be confirming and putting on paper what the terms are that you think you've reached an agreement on. And the other person getting it back will be obligated by law, and probably will send you something back that says, "No, that isn't what we agreed on. I misunderstood." And you'll get clarification. So the one purpose of a confirming email or letter is to get clarification in the event you misunderstood what your agreement is. The second purpose, of course, is to reconfirm what those terms are, because people that have reached an agreement of their own volition, that they enter into voluntarily, are far more likely to abide by it than when told by someone else what they have to do, whether it's a judge, a jury, or a police officer, or something else. So if the person you're dealing with, again, it could be in the business setting where you've reached an agreement with a vendor that says, "Hey, sorry about that screw up. We're going to take care of it on our end. We're going to do this, but you're going to make sure that invoice is paid by this date, and you're going to wire the funds in. So that's terrific. Really glad that you're able to help us out, and we're able to help you out. Look forward to doing business with you in the years to come." Whatever you want to say. But what have you done? You've now created something tangible. Not just your testimony if later there's a problem. Not just your testimony about, "Well, we were on the phone together. Here's a copy of my phone record showing we were on the phone for 26 minutes. And during that time, I agreed and said I would do this, and they said they would do that. And so we have an agreement." Well, what happens when the other person gets on the stand and testifies, "Yes, we were on the phone for 26 minutes, but I never reached an agreement and said I would do that"? Well, it's just a matter of who the judge or jury believes. Wouldn't it be better to say, at the end of that conversation, "I sent Tom an email, and here's a copy of it, and I never heard back from Tom, so I assume that when he got it, he must have understood it and agreed to it." Now, there happens to be in the law in virtually every state something that would be like an estoppel is one of the terms used. If you get a confirming email or letter and you don't agree to what it says, you didn't agree to it, or those terms don't work for you, be sure you send right away by letter or by email, basically sending it in the same form that it came to you, depending on whether timeliness is an issue, maybe a fax, and keep a record of what you sent, disputing it. Say, "No, I'm sorry, I received your email, but I did not agree to this," or I agreed to part of it, but not all of it. Here's what I did agree to. So what the other purpose is to elicit a response from somebody you send it to clarify what the terms are. And again, if you don't get something back right away, you can pretty much count on it. And isn't that a great thing to do? So you've created a record and you've confirmed the terms, eliminating most often any confusion or disagreement about what those terms are. Terrific. One way you can avoid having to go to an attorney at a later date. But if you need some help, if you want some coaching, some training, or some guidance, please go to $99lawyer.com and book a session. I hope this helps a lot of you, and please submit your questions and we'll try to answer them on a weekly basis. Thanks so much.